A second look now at the intersection between keeping us safe and keeping the government out of our business. Following up on a blockbuster ruling Monday, civil rights advocates on the right and the left cheered a federal judge's ruling that the government's big sweep of phone and data records is probably unconstitutional. The case involved an NSA program which has picked up records on millions of calls and texts made by ordinary Americans. The judge said it almost certainly violated constitutional protection, the Fourth Amendment, against unreasonable searches. Former NSA contractor Edward Snowden first exposed that program. He is still in hiding now in Russia, trying to avoid criminal prosecution in the U.S. Today, Snowden applauded the judge's ruling on this, and he said he has more information to offer about U.S. spying. He says he will give Brazil the details in exchange for asylum in that country. The White House says, though, this is not going to happen.
What I can tell you is that Mr. Snowden has been accused of leaking classified information, and he faces felony charges here in the United States. He should be returned to the United States as soon as possible, where he will be accorded full due process and protections in our system. So that's our position, and it has not changed.
Tough questions about the future of the NSA data mining program as President Obama met today with chief executives from the top tech giants. Those include Google, Apple, and Twitter. For those companies and the nation's security chiefs, the judge's ruling could be a real game changer for spy operations. We're joined now by retired Colonel Cedric Leighton, who's a former deputy training director for the NSA. Also with us is Elizabeth Goitein, who is the co-director of the Liberty and National Security Program at the Brennan Center for Justice. Elizabeth, I want to begin with you, just to give us some perspective on how significant a decision this is in the legal community.
It really is a watershed decision. This is the first case to say that what the NSA is doing is probably unconstitutional. The case is in the preliminary phases, and so it's not a final ruling, but the judge basically said that he signaled very strongly that he was going to find...
His language was quite firm.
Very, very firm. There was nothing tentative about it. And he said that he was going to find the collection of telephone records in bulk unconstitutional. This is very significant because up until now, courts who have been looking at the collection of telephone records have applied a 1979 Supreme Court case to say that people do not have a reasonable expectation of privacy in their telephone records. And what this case said was that case doesn't hold anymore. Changes have been so significant in technology, in the circumstances, that we can't rely on that case.
We can't live in 1979 anymore.
Exactly.
Colonel, I want to talk just on a practical level. What does this mean on a day-to-day basis? Obviously, there's a stay on the judge. The judge applied his own stay on his own order for the time being, but what would the long-term effect be, practical effect be for the NSA?
Practical effect, just from a pure operational standpoint, Joey, is that NSA is going to have to change the way it collects this kind of data. Obviously, the intent of the judge's decision is that it not collect as much data and that it be more focused in its collection efforts. That is probably a good thing operationally because, personally, I believe that it is very important when you go for law enforcement type issues or you go for any type of surveillance that you focus that surveillance effort on the targets that you really want to collect against.
Otherwise, you're not doing it very efficiently.
Exactly. And, it's very interesting because when you look at what the Soviet Union did with its intelligence agencies back in the days of the Cold War, 1970s, 1980s, they collected a lot of data. And at one point in time, the director of NSA at that time, Admiral Studeman, was asked, do you think, he was asked by Congress, do you think that all the information that the Soviets are collecting will actually, result in us being compromised as the United States? And the answer was no. They're collecting so much information they don't even know where to begin with their analysis of that information. NSA, with the current setup, has to be very careful not to fall victim in a trap like that, because if it does, if it gets too much data and doesn't analyze it properly, there could be a lot of false leads that are generated, and there also are situations where the operational focus is diluted, and you really want to be focused on the types of things that you really want to go after. You want to go after the Tsarnaev brothers, you want to go after people like that, and not at people that are not after people that are innocent.
But is there any evidence that taking a wide brush, the biggest vacuum cleaner hose you could find to suck up all the data, is there any evidence that it has stopped any sort of acts of terrorism?
A lot of the evidence is classified. What I can tell you is that there are indications, there are certain cases where it contributed to finding people. Now, the difficulty that the intelligence agencies have is when they go in and they say, okay, we use this particular type of source to go after a particular type of person and to get somebody, bring somebody to justice. That is always only partially true because there are so many sources that are used. For example, you will have an informant. If you have a good ironclad case, you will have an informant. You will have a wiretap that is specifically directed against that person in many cases. You may have specific intercept once you know exactly which person to go after. But if you don't have all of those things, then you start with one area, which is in this case the metadata collection of the telephone records, and then you narrow it down, and then you get into the other cases.
Elizabeth, on this notion of, look, technology, we've all acknowledged, has changed dramatically over this time. Perhaps the challenge of this particular kind of protocol is that you can't keep up with it. And maybe the initial notion was, look, we don't know what else to do. Let's just collect all the data we can and see what we can do with it.
That sounds exactly right to me. And part of the problem is that we've had trouble keeping our laws up to date with technologies. Technologies very quickly outpace the law. Courts are very slow to react. Institutionally, that's just how they work. It takes years to get through any one case, and courts wait to see what other courts are deciding to accumulate a body of precedent. It's a very slow process changing the law in the courts, and Congress tends to rely for questions like what kind of a privacy invasion are talking about on existing precedent, which then becomes outdated. So we don't really have a good mechanism for updating our law to keep up with technology. It's something we're really going to have to look at in the future. This will happen again.
I guess for all of us as ordinary citizens, what we wonder is, how intrusive is this really to each of our lives? I mean, look, you know, how much am I exposed because I use my text, because I send emails, because I send emails out of the country?
Mm-hmm. You know, from my standpoint, you're not exposed very much at all. Now, the fact is that your metadata is collected. In other words, the basic information as to, you know, the number that you dialed, how long you spoke, the location of that other number, your location. Those types of pieces of information are there, but they will not be accessed under the current program. They will not be accessed unless and until there's a reasonable suspicion that you are connected to somebody else that is involved in terrorist activities, for example. So, in other words, the data is stored, in essence, in a data warehouse, and then it is accessed when, you know, let's say you're talking to, you know, Abu X, for just make up a name here, and Abu X is a known terrorist. Then at that particular point in time, then your data would be accessed, and there would be, you know, some degree of reasonable suspicion that you have some connection,
that I've been exposed,
and that you've been exposed at that point.
But people, as ordinary citizens, remain quite suspicious of this. And in this case, we're only talking about two individuals, but there are other challenges to what the NSA is doing. Right?
There are several other lawsuits that are ongoing, and there are groups, including right-wing and left-wing groups across the political spectrum, gun rights advocates and social justice activists who are saying that they have been affected because they have been chilled in their activities, in their ability to express themselves, you know, through their telephone calls and through their communications, out of fear that they could be a target. And I would also say that in terms of whether average people have to worry about whether or not they will be affected, even though the government is supposedly only querying the database, or supposed to only query the database when it has reasonable suspicion, it can then go 3 hops out from that one number and gather the contacts of everyone that the suspected terrorists talk to, everyone they talk to, and everyone they talk to, which very quickly sweeps in millions of clearly law-abiding Americans, not to mention the fact that there's ample evidence through the FISA court opinions that have been made public that the government has routinely not abided by the reasonable suspicion limitation when it accesses and disseminates information.
Certainly something that all are keeping watch on. Thank you both very much. Colonel Cedric Leighton, thank you for your information. Also with us, Elizabeth Goitein from the Brennan Center for Justice.